Hi everybody, Armine Bazikyan here from Bazikyan Law Group, and today I wanted to speak to you about community property. I wanted to talk to you about this method of owning property. This is part 2 in a 3-part series that we're doing on the various types of property ownership. So hopefully you'll gain some knowledge from it. Most people don't know how they own their property, what title they took to their property, and this is troubling because depending on how you took title to your property, it can put you at a tax disadvantage as well as a legal disadvantage. So today we'll discuss community property and what it means. So community property by definition is when 2 people own the property and those 2 people are married. So it's a married couple that buys a house, for example, and they decide to take the title to the property as community property, meaning they consider it to be both of theirs. Now, this is a very common form of property ownership here in California, but what this property ownership does not have is what is called a right of survivorship, meaning when you take title to your property as community property, there is no right of survivorship, meaning if one of you dies, the other person doesn't automatically get that portion. So let's take a step back and look at it for a minute. So when you take title as community property, you and your significant other each own 50%. And what you're telling the world is we own 50% each, and I can do whatever I want with my 50%. I can sell it, I can create a will and say that it goes to my friend. So you can do whatever you want with your 50% interest. And because of that nature of community property, there is no operation of law that allows the property automatically to go to your husband or your wife or whichever it is. So you have to designate the person in order for them to receive it. So that's why a lot of times couples won't like taking title to property as community property, and they'll instead choose joint tenancy, or they'll be advised by somebody during the purchase process to go with joint tenancy instead, because as we learned from last month, joint tenancy allows the property to automatically go to the survivor. So that's one of the disadvantages of community property. But community property does have a ton of great tax advantages to it, so it's still the better choice for married couples. And luckily, because of a relatively new law in California, you can actually have your cake and eat it too, meaning you can take what's called community property with right of survivorship. So this is a relatively new form of title in California, and it's pretty much as if you're taking something as joint tenancy and community property combined together. So what you're telling the world is, I hold this property as community property with my wife or my husband, but I agree that if I pass away, she or he has a right to survive me and take my portion. So it's literally called community property with right of survivorship. And this is probably the best alternative for married couples who haven't done any planning in place, because what it allows you to do is automatically give your 50% share to your significant other, to your partner. So it accomplishes both goals of probate avoidance as well as allowing you to have all the tax advantages of community property. However, what this scenario does not take into consideration is when there's a simultaneous death. So let's say husband and wife go on vacation together and they're both tragically killed or pass away. What happens in that scenario? In that scenario, the property will go through the probate process. So although it avoids probate for one individual, it doesn't let the world know what happens to the property when both of them pass away. So you definitely still need to put in place a comprehensive estate plan that addresses that issue. So I'll give you 3 examples. Husband and wife take property as just community property. They take title as community property. When husband passes away, his 50% interest has to be probated because they took title as just community property. Through the probate process, at the end, it'll eventually come to a point where a portion of it does go back to the wife, but the probate court will decide that. So the second scenario is the same, except instead of taking the title as community property, they take it as community property with right of survivorship. So in that scenario, when the husband passes away, we file an affidavit with the county recorder's office, and by operation of law, we're able to transfer his interest to the wife without the need to go to court. The third scenario would be both husband and wife take title, community property with right of survivorship, but they both pass away together. So then a probate is going to be needed to determine how the asset gets transferred and to who it gets transferred, to their kids if they have any, to other family members, depending on what the scenario is. So depending on how you choose to hold title to your property, it depends. You're putting yourself at a tax advantage, you're putting yourself at a legal advantage. So it's very important to pay attention to what you select when you're purchasing a property on your escrow instructions, because it does have a legal impact and it does have a tax impact on your overall financial well-being. So if you have no clue how you own your home or your investment property, feel free to give us a call and we will let you know how exactly it is that you hold title to your property, and we'll be able to give you some input and some advice as far as your particular situation is concerned. Our consultations are completely free, so feel free to take advantage of that, and we will talk to you soon.